Order. Welcome to the first public session of the Business and Trade Select Committee in this Parliament, where we are returning to what is unfinished business for this committee, which is justice for the sub-postmasters who were wronged by the Horizon scandal. Thank you very much indeed for joining us as witnesses, and let me thank those sub-postmasters and former sub-postmasters who are joining us in the public gallery today. I hope that the message that you take from this committee hearing today is that we will follow this tenaciously and relentlessly until justice is done in what is the biggest miscarriage of justice in British history. To our witnesses, thank you very much indeed for joining us. You were all wronged by the Horizon scandal in different ways, and you have all, therefore, sought remedies and redress through different schemes. So Alan Bates, you are applying through the GLO scheme. Jill, you're applying through the HSS scheme, and Derry, you're applying through the HCRS scheme that deals with overturned convictions. But Alan, perhaps I could start with you. I mean, first, congratulations both on your recent nuptials and on your knighthood. We're now 2,785 days on from when you first commenced your action against the Post Office. Have you now received your settlement for redress?
No.
No? What on earth is going on?
I wish I knew. I think the bureaucracy of the whole thing is definitely a big problem. It's funny, I've jotted a few notes down. My initial claim went in on the 12th of October 2023. So it's over 13 months now since my original claim's gone in for the scheme. I've received my 80% of the offer, which, like most people have, which is all very well and good, but we don't seem to be getting very far forward. And one of the things I've noticed of recent is I keep contesting what DBT keeps saying about my claim, but one of the things I've noticed of recent is that ever since these schemes began, behind the scenes, that they've been shifting the goalposts. In other words, the wording on the paperwork, on the terms and conditions of things like the GLO compensation scheme guidance and principles have changed on a number of occasions since the scheme began, and certainly since my application went in.
So what do you think is going on here?
I don't know. I really don't know, and I think this is something that we're quite pleased that you're looking into, the committee's looking at. They do get bogged down. I think you'll hear from the lawyers later some of the problems they've had along the way. But speaking for my own personal case, is I don't know whether it's something personal about my case or whatever. I know I'm towards the front of a lot of the claims, but it's they just seem to be. You're told it's one thing, the scheme, and then you find out it's something different. Perfect example of that is when we started off this scheme, it was never meant to be purely about legal considerations, legal technicalities in anything. But they seem to be applying this the whole time. Legal tests seem to be key, the whole point. Now, to give you an example of what I've just been saying about them changing or shifting the goalposts in it, in the original GLO scheme guidance and principles, I'm only going to do the front page, I'm only going to do one of the paragraphs as an example in there. In the original one, it says, in point 1.2, in awarding compensation to postmasters, the scheme will be guided by consideration of fairness in addition to applying established legal principles.
Was your offer fair? Sorry? Was your offer fair?
In whose eyes? This is the big thing. Where's the fairness test come in? But I'll get to that in a moment. But what I would say, the more recent version, 29th of November 23, that has changed. That it actually says the central goal and key overriding principle of the scheme is to deliver compensation to eligible postmasters full and fair, restoring them to a position that had not been in. Decisions will be taken in light of established legal principles. Purely, what they've lost from that is fairness out of that phrase there, even though they do repeat fair and whatever, fair and full. And the other point on that test is where we're not clear about where fair comes in. Further on down, 2 sections down, it actually, 2 paragraphs or 2 sentences down. The scheme will take into account all relevant facts and matters presented at the claim in order to produce a fair result for the sub-postmaster. Yeah. Now, is it in the eyes of the postmaster that it's fair, or is it in the eyes of DBT? They think it's fair. There's no clarification on the fairness test in all of this, and I think that does cause a bit of a problem.
So we've got a missing fairness test, you would say?
I would say that at the outset. Well, it promises in the initial paperwork, it promises to a fairness test in addition to the applying established legal principles, whereas later on, the version that's there, it only mentions established legal principles. Yeah. It's dropped the fairness from there.
And the stage of the process where this is going wrong is in the negotiation. So there was an initial offer put on the table,
yeah.
And it's now being negotiated endlessly by the sound of it.
In my case, I wasn't involved in my original claim in putting with the figures for my claim. That was left to my solicitors and also to the accountants they were using to assess everything. So they put my claim together. They submitted it, I agreed it, I submitted it. All I did is provide information and answer questions that they wanted in that case. It was rejected, so it came back. And I looked at it at that point there and actually reduced what my claim was because I felt that was fair. That was me applying the fairness rule. But it was still rejected by DBT when it went back. And then they just processed it through the different stages.
Did they tell you why it was rejected when they rejected it?
Oh, they just don't agree.
Don't agree with it. I'm trying to understand what you think is the motivation here. I mean, is it lawyers just trying to keep the bill down? Are they trying to time people out so that people basically die before they get their redress? What do you think is the motivation here in those that you're negotiating with?
I think there were a lot of loose ends when the scheme was set up, and these should have been nailed down to start with. I also think that ourselves, like the JFSA, or even the lawyers, weren't involved in the finer details or how the briefing of the government's lawyers who were assessing these claims, how they were going to be instructed to deal with them as well. And I think that would have been very useful at an early stage as well. So everyone knew how things were going right from the outset. But it seems that though we agreed a basic scheme at the outset and some of the early documentation in to do with the scheme, and then our lawyers sort of took over on our behalf, the DBT went off and they instructed their own lawyers, who then instructed their own accountants, and we don't know what they were instructed
and
to do with.
Do you know when this is going to draw to a close?
I wrote to the Prime Minister about a month ago.
You did. You've written to him twice.
I wrote to him initially about a month ago, and I said that it should be finished. It needs to be finished by the end of March 2025. A deadline should be set, and we asked for his help in setting this deadline. I never received a response. I wrote to him a few days ago to remind him that I'd never received a response, and also now we're at 5 months until the end of March 2025.
So the Prime Minister said on LBC on the 5th of January, he was obviously leader of the opposition then, he said this to the government. He said that the government should now, quote, get on with it, do at least get that bit right. But you've not yet had replies to your letters to the Prime Minister about setting a deadline.
That's quite right. And deadlines do need to be set. You know, you can't have an endless piece of string in this. People have been waiting far too long, over 20 odd years. There's over 70 have died along the way in the GLO group in there. There are people, well into their 80s now that are still suffering and still having to put up with this as well. They shouldn't. They really shouldn't.
What happens if this drags on for forever and a day? Would you ever go back to court with a crowd-funded campaign for justice?
I would never say never. I mean, it is a consideration. I will not say I haven't spoken to people about this, but I do know if we decide to go down that route that we're going to halt the current scheme. And it's going to be at least another 6, 12 or even 24 months before it moves forward in that direction. Now, that might be a choice people are prepared to take. I mean, we've got a group meeting coming up in a few weeks' time, and that's one of the options that we're going to discuss. That and a few other options as well. But we've got to move this forward. And, hopefully after today, you'll be able to bring a bit of pressure to bear on them as well. It's the deadlines that need to be set in this. They're terrified of having deadlines set, the department.
Thank you, Liam, and thank you very much for joining us, and it's wonderful to meet you. I wanted to just pull up a little bit more on what Liam was just saying, if I could, Sir Alan, because you previously spoke about how you don't think that the financial redress was either fast or fair, and I think you've been more than fair in your response to Liam, but I wondered if you could paint a bigger picture as to what do you think is fair, rather than allowing someone else to set that standard of fairness. What would you say if you were to write that standard?
Well, I know there are people who are working their way through the scheme and who are achieving and settling their claims. And I believe, because I get letters and emails from them, that they've felt that they've had a fair offer or they've accepted a fair offer. But when you're starting, or when you're being offered a third of the amount in the first instance and all the rest of it, when your claim's been put together by professionals with the support of legal professionals, by the support of accounting professionals, and then you've got to, if you like, argue your way all the way from the ground all the way up in it, it doesn't seem very fair, does it, if you're starting from there? So it's a tough battle, and we shouldn't need to do that.
And I think you've partly answered what I was going to ask, which was about how you feel other members of the Justice for Sub-Postmasters Alliance feel about that fairness. So some clearly think they've got a fairness, but what you are describing is that they're very different experiences of this. And have you got any sort of stories that you wish to share from the members of the organisation?
Well, I think the lawyers will be able to give you sort of numbers involved in this, who are through and all of that. But the impression I get is certainly those who took the 75,000 offer in the first instance and they've moved on. I think they've obviously felt it was a fair result for themselves in there, and they can get on with their lives because obviously their claims were relatively small. There then have been a proportion of people who also have lower ending, above the 75,000 but lower claims, and I think they're working their way through, and those have probably been resolved. And I know some of the more complex cases have as well. But the bulk of those that are left, the few hundred that are still outstanding, they're probably the more complex cases, and they're the ones that are going to take a lot longer to resolve, and there are going to be far more challenges along the way.
Thank you.
I may not briefly, and then Rosie Writing.
Thank you, Chair, and thank you for being here today. Just splitting the kind of four schemes into two, so there's two with a C in it, conviction in it, OC1 and HCRS, and then there's GLO and HSS. So just focusing on GLO and HSS, where people were not actually convicted, if I'm correct. So in both the GLO and HSS, we're looking at a 75,000 as a kind of the headline sum. I mean, I think you've really answered quite a lot of my question I was going to do, which is that seems to be, given the misery that people went through, frankly, to be not very much money for the years and years of pain. And that is why, presumably, a lot of people are like, hang on, this is worth arguing about, because 75,000 just doesn't cut it. And I'm not sure whether the DBT actually are on the same page on that. What's your view of that?
Well, I think I think the 75k was a band brought in because there were a lot of smaller claims in there, and I think that was a good option to sort of, a few thousands or something of that nature, or 10,000, 20,000. I mean, as I say, the lawyers will probably be able to answer those questions better than me on this. But there's been the banding worked well there, and possibly banding should be looked at levels above that as well, even if it only clears out a proportion of them relatively quickly. It could be an option that could be explored quite quickly, I think, by quite a few individuals.
Thank you. Thank you. Rosie Rising.
Thank you, Chair, and thank you for coming in today. Jill, I understand you're here on behalf of your mother, Janet. I was just wondering if you could tell us a bit more about her story.
I've wrote a little bit down. Am I okay reading that out?
Yes, of course.
Yeah.
So my mother was a postmistress for almost 16 years. Like a lot of other postmasters, she was highly regarded in the community. Our first office, she won Best Post Office and represented the North East in the finals in London. Our next post office that she bought had the Horizon system fitted, more or less, after taking over. And the problem started immediately. The helpline were just giving her the same answers all of the time. It was just, no one else is having this problem, and you need to make good the shortage. Finally, after several requests, we did get a gentleman to come out and have a look and sort of do an audit and see where the problems lay. He couldn't solve the shortage problem, and again he told me mum to make good the shortfall. More than 20 years later, when we've gone, obviously Alan's opened this, and we've received some paperwork from the post office, and actually in that paperwork, the gentleman reports, he actually says his words, and I quote, "I think Mrs. Moorhead is hiding something. I have told her she must put the money in." He made this allegation without any proof whatsoever, and this was the type of people that was being sent round to help postmasters. My mum was quite fortunate because she was able to put the shortages in. She was able to, like I say, she put the shortages in, but she did worry. She did live under the stress, the anxiety of a shortage occurring that she wouldn't be able to afford. As well as a postmistress, she was a former school governor and a magistrate. So as you can imagine, she was very conscious that if anything was to come out, the media would have a whale of a time with her. And obviously she wouldn't be looked upon leniently in a court. Sadly, she sold the post office, just totally disillusioned, at a ridiculous price. And then she we lost her 2 years later, and myself, I'm here for me dad, me 3 brothers and me mum. It definitely affected my mum's health. The stress, the anxiety, how she lived, it definitely did. And as far as our offer goes, like what Alan said, we've had 80%. We got above the 75,000, so we were sort of maybe the next category up. When I initially made the enquiries, I was told the scheme was closed and that they were no longer taking anybody else on. I then contacted our solicitor, who he sort of said, well, we need to try and get it reopened, you need to push, you need to, we're trying to get as many people to get back onto the scheme. Eventually I got a pack through to fill in, and it wasn't easy to fill in. I did it myself because obviously there was no legal team would take it on because the scheme wasn't open. So I filled it in myself. I was given an offer sorry, I'm jumping ahead. It was October 22 when I got that form returned back to them, and it was August 23 when we got our offer. So 10 months later, they gave us an offer. I then contacted Neil Hudgell's solicitors and was advised not to accept the offer. They would get an interim payment for us. And since having the solicitors deal with us, our offer has turned out to be just over a quarter of what has actually been found in the forensic evidence of what we lost.
You spoke about the worry and stress that your mum lived with. Can you tell me how this has impacted the wider family?
Absolutely. It was just, I mean, now we sort of, obviously we're reliving it because we're going through all of this and we really don't need it. You know, they're asking for probate certificates stamped by courts, and you can go online and you can check if probate's been granted. And it's just stumbling blocks all the time. So that's affecting us now. But I think as a family, when we were younger, Mum was always just preoccupied. She was always just very anxious. She was agitated. She was stressed. She didn't want to go to work. And I mean, she went from winning the best post office in the northeast to loving her job to just being totally disillusioned.
And Weston.
Thanks, Chair. Jill, thanks very much, and thank you all for being here. Can you just talk through a little bit more about the experience that you have felt going through the HSS scheme?
Well, it's not very user-friendly. It's very legal. The letters that we've received, they're not nice letters. They're not letters where you think, they're trying to help you or you're gonna get through this. And I think it's more about the time. I'm sort of doing this now for my dad. My dad's 74. He's had 10 years without, it was 10 years yesterday since we lost my mum. He's had 10 years of not having mum, and then the previous years before that, 11 in the post office, of just constant battling with shortages and it's just...
When the post office first made you an offer, did you consider it to be fair?
We did, if I'm perfectly honest. We did consider it to be fair because we weren't aware of what we'd actually lost. We contacted the post office and they sent us all the documents they had, redacted letters and what have you, accounts, but there was 5 years missing. There was 5 years of data missing. And then there was points of the claim that the solicitors have pointed out which weren't made aware to us. So, like for instance, cost of the property. Mum sold it and she sold it at a loss to get out. But we didn't think that would have increased by the time she would have sold it in maybe years to come if this hadn't happened with the post office. So the points like that the solicitor sort of helped us with, and that's, like I say, increased our case. And our offer that we've received, like I say, it's a quarter, just over a quarter of what we've actually lost.
You mentioned in your earlier remarks about the fact you submitted back in, was it October 22?
October 22.
And you didn't get a response until August 23, 10 months. Why do you think it took so long?
I really don't know. I put it down to maybe the scheme being closed and them just sort of putting them to one side to see whether they were going to reopen it or not. I don't know. I can't answer that.
Okay. You're talking about, I'm sorry about the loss of your mother 10 years ago yesterday. And clearly the anxiety played a big part, I'm sure, or can imagine, on her illness. You said that the lawyer told us that, your lawyer told us that the post office had said that stress really didn't play a part, and that you couldn't demonstrate or couldn't prove that had an effect. What was your reaction to that?
I think it's absolutely disgraceful because I really genuinely believe that the stress shortened my mum's life. It's been proven stress does, brings on all sorts. But yeah, I think it's absolutely disgraceful. you can't put a price on that. How do they know what they didn't live in the shoes? They don't know.
Okay. The other thing that your lawyers have said is that in disclosure provided by the Post Office, that they laid blame on your mother for the shortfall losses. Can you tell us a little bit more about that?
We only found that out when we received the paperwork from the post office after I'd filled in the form. And so, like I say, more than 20 years later, and there was a redacted letter, and like I say, it literally said, I think Mrs. Moorhead is hiding something, and I've told her to put the money in. And so everybody that read that report, when he went back to the office, because he couldn't find any problems, he came up with this allegation to cover his own inadequacies, because he couldn't find the shortage or the problem. So 20 years of people reading those reports thinking Mum's a thief. And
Let me just ask, when your mother was originally asked to repay the money, how long was she given to repay?
he had to put it in on balance day. So we would
So straight away?
Straight away. So our largest shortage was £5,000, and that came to light. It was something the Horizon system was doing, where it was doubling the first class stamps. So you were looking like you had twice as many. So that the cash, I mean, obviously stamps were cash in the post office. And yeah, so that it was literally, you'd done your balance on a Wednesday, and if there was a shortage, you had to start that following week on the Thursday morning on an even keel. So that money had to be put in.
Where on earth did you get £5,000 from by the close of business?
I don't know, I think she must have had it hidden somewhere. I don't know, I really don't know. That was left to Mum to deal with. But I mean, we had other businesses that we ran as a family, so I think we did sort of pull from one to the other to compensate.
Thanks, Jet. Just to come back from that, I mean, it was really only because that you had, or she had other businesses in the family, that she was able to offset some of those monies.
Absolutely.
And do you think, sort of in retrospect, I mean, how long were she was able to sustain the business because of that? And if she hadn't had those other businesses, she'd have lost the business a lot sooner.
Absolutely, she definitely would have. And that was she was living with that anxiety all of the time, because it was just, what's Wednesday going to bring? What shortage are we going to have? Am I going to have the money to put that in to start Thursday again? Because you phone the helpline, and everybody on the helpline was just, well, nobody else is having this problem. And I had that first hand. I rang the helpline myself on numerous occasions, and it was, nobody else is having these problems. You need to make good the shortage. And that was all we got.
Finally, the duress, the anxiety, the first shortfall was when, and the final one was when?
Sorry.
The first shortfall that was discovered was when, and how many years later was the final
first shortage was within a week of Horizon being installed, and that was put down as teething problems. But I think, if I remember rightly, I think it was installed in the September, and she was still having shortages by the December, and she was running the old system, the paper system, alongside this. This system was working out, but the Horizon system wasn't, so she knew it was something the system was doing, but didn't know what it was doing.
Okay.
So you've been waiting for 20 years for redress,
Yeah.
and yet your mother was expected to make good the gaps in a balance sheet
Within 12
minutes.
hours. Yeah.
Ordinary.
Yeah.
Just wanted to check your experience about applying for the compensation scheme, for the redress scheme, because a lot of people have said to us that you get hit by a barrage of questions that are really quite difficult to answer. You said that you answered those questions yourself.
Yes.
Can you just tell us a little bit about that experience of trying to answer all those questions?
It was really long-winded, and it was really in-depth, and they were asking questions of things like what the shortages actually were and how many times it occurred, how would we know that? You know, how I was doing this on behalf of my mother who'd passed away, and it was just impossible to answer. So I was trying to be fair. I was trying to, you know, so we sort of did a range of, we knew the largest shortfall was 5,000, and they ranged from £5, £50 throughout. So like I say, I couldn't put a figure on that, so that was left to the post office, and then they came back and made an offer of what they thought. And like I say, our offer that we were given has turned out to be just over a quarter of what we've actually lost.
You were kind of expected to be psychic when you were...
Yeah, absolutely.
Right.
Absolutely.
You're psychic?
Not at all. Not at all.
But how did you feel when you're being asked to put these numbers down? I mean, that doesn't feel very fair to me.
It was just a case of, what do they expect? What do they want me to do here? I haven't got a clue. I'm filling this in as best I can, yet they're ready to sort of jump on us for, you know, this needs to be sorted, that, you know, we need the probate certificate, we need this, we need that. Yet they were expecting me to know the figures from 11 years ago at the time. Sorry, 20 years ago.
Yeah. Would it have made more sense, do you think, if you were actually given a bit of legal or other advice and support up front?
Yeah.
When you were filling that form in?
Yeah, definitely. I think, I mean, it just goes to show that asking me for figures that they haven't even got themselves, because when I did get the data that we requested, there was 5 years missing that they didn't have, yet they expected us to know what we've lost.
Yeah. Let me come to Joshua Reynolds, Charlie, and then I'm going to come to Gregor to move us on.
Thank you, Chair. Jill, your scheme's being administered by the post office.
Yeah.
So was the expectation just fully on you to deal with all of this, fill these forms out, have everything? Were you given any support by the post office in terms of trying to get that?
Nothing at all.
Even though they knew, obviously, with the 5 years gap in the middle, they knew the numbers that they were expecting you to just provide them?
Yeah. I have no idea. And when they sent the documents that they did have, they were practically ineligible. You just couldn't read them. You had magnifying glasses on them, and they were so tiny. It was just disgraceful, but it wasn't helpful at all.
The expectation was for you and other postmasters to be able to do all of this, fill everything in, have all of that expertise around you, when the post office themselves had no idea in reality, because you couldn't decipher it. There was no way they could.
Yeah, exactly. And like I say, they expected us to have figures that they didn't even have. Yeah.
Charlie?
Yeah, thank you, Jill. Thank you. Just playing that back about your mum putting in money repeatedly, and then finally the post office or the auditors of the post office work out that actually, that there was a 4 times differential. So they ultimately were able to figure out what she had put in, and if they could work it out for your mum, then why aren't they working it out for every single one like that?
I think for myself, what they've worked out is that there's things that I didn't know I would be able to claim for. So I filled the form in as best I can, and I sent that off. We've got the offer. It's then gone to the solicitors, and then if there was, so for instance, there was a distress and inconvenience. We'll pick on. You can't put a figure on that. It's not actual. You can't put a figure on it. So they just gave us nothing. We just got nothing. There was 3 headings that fell under the unquantified. It was said, and that was because we didn't put a figure on it, because we didn't know and we couldn't. So they just decided, they'll not get anything for that. Distress, personal injury. I think personal injury was at the 8,000, if I remember rightly. Yeah.
You think that what the post office asked of you was fair? Absolutely not. No. And I mean, even if Mum had been alive and they'd asked Mum she would have known more than I did. They knew I was making the claim on behalf, and they knew I wasn't the postmaster. They knew I just worked in the office.
So absolutely not, no, it wasn't fair.
Did the amount of detail that they asked for, did that slow down your claim?
Yes.
Did. Okay.
It must have took us 2 months to fill the form in.
Wow.
Yeah.
Thank you.
Thank you, Liam, and thank you so much for coming today. So your mum was obviously running a paper copy of what was happening and also the Horizon.
Yeah.
When did she present the case to the post office to say there is discrepancies, and when did they actually start taking note?
We made lots of phone calls about little shortages, and again it was just, I mean, they would just tell us to put it in. I mean, I've seen me and Mum, the programme that was done with Alan, when Joe Hamilton was on the floor with the dockets, that totally resonated with me, because I've done that with me Mum. Yeah, so it was just... Sorry, can you repeat your question there?
So, as you're running the paper copy and the Horizon, when did you first alert the post office saying there's discrepancies between what the paper's running and what is the Horizon systems running?
That was the December, when the gentleman came out to the office and we showed him what we'd been doing, and he just wouldn't...
How many times did you have to speak to them to say there's actually something wrong now with the system? When did you identify there's definitely the system problem?
I would say the December. I would say the December time, yeah. Mm-hmm.
All right, sorry, just to follow up on that question. The person that was sent out to look at the books, were they an accountant?
I don't know who they were. If it was just a gentleman that worked for the post office.
No.
And he sort of came out, done an audit, and yeah.
So you don't know if they were qualified to assess a set of financial books in front of them?
I don't know.
Thank you.
You're shaking your head, Alan.
No, I did a Freedom of Information request about the qualifications of the so-called auditors that Post Office sent out. And there weren't any. There weren't qualified auditors as well. And also, they refused to allow people to bring in their own accountant to check the books as well. That was another refusal they always used to do.
This whole process has been riddled with unfairness, and it doesn't feel like we've got rid of that unfairness. Just one last question before I hand to Gregor Poynton, which is, do you ever feel that as you were going through the application for redress, do you ever feel that you were given the benefit of the doubt or not?
There was a little bit of the form that I was filling in, and I remember because Mum and Dad sold the post office for, I think it was about £31,500 less than what they'd paid for it 11 years earlier, so Mum could get out. And I remember putting that figure down, and we had that asked for land registry, that asked for all sorts of paperwork to prove what we'd sold the business for. We had to get figures from our sellers that had to show the goodwill, the fixtures and fittings, and then obviously the property prices. So we had to get all that to prove that. And I think they did offer us the 31.5 to sort of meet that. But if I'm perfectly honest, no, I don't think there was no benefit of doubt given. I think it was
everything
just,
the post office put you through, despite all of the time, there is still no benefit of the doubt along the way. Gregor Poynton.
Mr. Lewis, to you next. I mean, we're going to look at the administration structure of the redress schemes, but I think it's just important to hear the human story before we start, sir. So be keen to hear from you in terms of your story and the impact that's then had on you.
Okay, well, what I heard resonates very closely. It's 6 years tomorrow that I lost Mum, and she used to work for me before her retirement with me in the post office. I ran the post office in Penrhydeudraeth I ran the shop from 1979 till March this year. I ran the post office from 1985 till the 15th of March 2011. Beware the Ides of March. We'll never have such a... I should have listened more to my English literature master at school. When everything went belly-shaped. We'd worked with Horizon, until the previous August, September, when they did the upgrade. And that's when we started getting massive shortfalls. I was a senior county councillor. MP who's here today sat on the same cabinet with me on Gwynedd Council, and public duties were my life. That all came to an end on the 15th of, well, the auditors, Mr Bradshaw, arrived on the 15th of March, and I resigned everything on the 15th of July because I was advised very strongly to plead guilty and to make short the 53,000 they claimed. My parents had to take equity release on their retirement house. They'd both retired after a long career. Mum was a schoolmistress before working for me in the post office. My father was an insurance broker and another county councillor before me. So we're well known in the community. And we said, well, if you pay it back initially, we won't charge. And then they said, oh no, we found out you're a county councillor, you'll be front page news, we're charging. And that was that. So I was pleading guilty to try and reduce the sentence. I served 4 months in Her Majesty's Prison, Altcourse, and it was dreadful seeing Mum and Dad having to come in and see that. And I felt more for them than for myself. I knew what I was going through, but they could only imagine. You know, having said that, I was lucky. There were postmasters who had to go through far worse prisons than Altcourse. Another postmaster from North Wales, Noel Thomas, he had to suffer Walton, one of the old-type prisons. I'm not sure if I'd have survived that, but came out from Altcourse. The chairman of the magistrates came to pick me up from Altcourse on the day of my release. He saw a few of his old clients on that day. And then I just carried on running the shop with the post office, rented the counter from me for a number of years. And then I kept on running the shop, which the post office said was failing, for another 14 years until I retired on 31st of March this year. And in the meantime, I lost both my parents, had a divorce during that time, and depended on medication to get me through. I was very, very fortunate. My community and my friends and family stood by me. I didn't have any of the nasties some of the other postmasters had to. So I count myself as being very lucky on that. My community all knew me and nobody thought I was guilty. So I ran the shop, became somewhat of a recluse, didn't do anything publicly, couldn't do anything publicly until I received the letter of exoneration, quashing all I received it on the 22nd of August this year, 2 days after I got married to my latest wife, who stood by me. She used to fly in from Dublin. She was a bank manager in Dublin, in Naverton, and used to fly in from Dublin airport to John Lennon. She was on first name terms with people in John Lennon airport every fortnight to see me in Altcourse, and that was the sort of support that got me through everything. And so community, friends, family, and blessing, faith kept me going, but also the support of those family, friends, and community has been invaluable. I count myself as being very, very fortunate compared to a lot of other sub-post nurses and their families who have had it even worse than myself, and all those postmasters who haven't seen the day when justice was seen to be done for the first time. And thank you for the opportunity of coming here today as well, and the work you're doing as a Select Committee. We're very grateful.
Thank you.
Yeah, Mr. Lewis, you'd mentioned that the problem seemed to start when the upgrade came in. I'd be just interested to hear what you were seeing in that period, and if any communication you had with the Post Office about the problems you were seeing.
My retail support manager was very good and was trying to get to the bottom of things and couldn't understand. And the line was, well, yes, we're aware of everything. Leave it with me, we'll see what we can do. And that carried on until the March when the auditors came through, and then when the heavy mob and Mr. Bradshaw, the investigator, came through and started making the threats and saying, well, yes, come up with a good story.
Yeah. So you could tell there was something going wrong, but they couldn't. They weren't
No.
really helping. They weren't trying to get to the bottom of it on a
No.
discussed it on a sort of good faith basis. And then suddenly there was an investigator at your door, banging on the door, asking for the money back. And at that point, you mentioned you were looking to then find a solution. I mean, how were you able to? You said it meant your family were having to take money out of their homes and so on. So is that where you were looking to get to with
Well, before that, because I was so concerned about it, I approached my MP at the time, and I approached my bank to see anything we could put this in to try and see that we could go through it. And there was nothing we could do. This was 3 years after the crash. So, and the only people that didn't support me through the whole of it were the banks. The banks and the Post Office didn't basically want to know.
Joshua Reynolds. Sorry.
Thank you, Chair. You've used the word fortunate and lucky, and I don't want to speak for other members of the committee, but when I hear you say those words, it's heartbreaking to me, because you are an upstanding member of your community, and the fact that you feel lucky and fortunate because it's not as bad as others have experienced is truly awful. I want to talk a little bit about your experiences going through the Horizon Conviction Redress scheme. How has that process been so far?
Having listened to Alan and Jill, this started on letter of Poshing arrived on the 22nd of August. We were told that the redress scheme was in place and that we had a choice of taking the 600,000 or fighting for more, but that an initial payment of 200,000 would be made in 2 to 3 weeks. That was the understanding that we had, and that's my solicitors at Hudgels had. Started off, that was the first letter from Ministry of Justice. 2 weeks later, we had another letter from Ministry of Justice. They'd mixed up the reference numbers, my case numbers. The case numbers on both letters were the same. So we're not quite sure what the situation within Ministry of Justice was. When the Department of Business and Trade finally agreed that they'd had the right reference number, which was the same one, they said, oh yes, they'd be processing the claim. That was early September. That was 5th of September. And we were told, yes, you're registered under the scheme. Nothing was happening. And the staff at Tracy and Neil Hudgell were brilliant in supporting me. I'm sure they must have thought that I was a pain, because I was asking them every week, anything happening? And no, they were having weekly meetings with the Department of Business and Trade. They were taking, because I'd been through an IVA after coming out of prison, they had to have legal, even though we furnished them with a certificate of completion, which went back to 2019, I think it was. They said, oh no, that's not good enough, we have to check, we have to have legal opinion on that. The legal opinion seemed to be slowing the whole process down again. Then we were so told, well, you can have the 200, or do you accept, you could go for the 600 and draw a line completely. I said, and after what I've heard from the other colleagues today, I said, yes, we'll take the 600 because there's no fight left in me to go for forensic accountants, valuers. How do you quantify what the value of the post office was if it went for sale, and the property where I lived went for sale in 2011, and what it would be today without how long is a piece of string? So we decided, right, rather than fight, we'll go for the 600,000. Until last week, we had no inkling when we'd even get the initial payment. Lo and behold, it was announced, I think, after speaking with the staff here, that I was going to be in front of you. I think that was announced on the Tuesday. Oh, surprise, surprise, Friday morning, check the bank account, the 200,000 had arrived. Now, I try not to be cynical, but I'm finding it very difficult.
Miracle of a select committee.
And, oh yes, you have much more power than I thought. And then, but we were told, yes, there'd be a deed of agreement coming out with that. Hudgels, by the day, are still awaiting that deed of agreement or settlement deed so that we could progress and get the rest of the settlement. And that's where we are as of today.
And so you said that you've taken the deal with that 600,000 because you've got no fight left. Do you believe that that 600,000 takes into account all of that in your head, that financial and emotional loss that you've experienced, or is it a means to an end?
I'm not sure. I doubt it, because the 600,000 includes the 53,000 that we put in, plus the interest of what that would be by now, during a period of quite high interest rates the last few years, during a period of austerity when interest rates went up. And it includes what we would have got from a colleague share plan, which the post office had at that time. So looking at the heads of what would possibly be, I'm not sure. But as I said, after the experience of Sir Alan and Jill going through with the post office and with the DBT, I want to get on with my life and do other things rather than carry on fighting. The difference in my health since I had the letter of exoneration, I never knew how much it had taken out of me. Before that, I wouldn't get on the train to London, and never mind go out and do public interviews, etc., which I've done last few weeks. So I can't understand. In that meantime, I've come off most of my anxiety and stress medication, which had been going up. I was on the top end of things. Since August, I've been able to come off those. But the longer the fight goes on, I'm not sure. It's very difficult to quantify.
It's slightly against us, so I'm going to move us on just to some of the final things that we just need to check with you. Alison Griffiths.
Yeah, thank you. First of all, thank you so much. It's been incredibly moving hearing your testimony. The question I'm going to actually slightly change the question I wanted to ask in light of what you've been saying, but the question I was going to ask, so I'm going to ask you two questions. First of all, do you have faith that the schemes are designed with the best interests of the sub-postmasters in mind? But the question I'm going to actually ask is, do you think they were intended to be designed with the best interests of the sub-postmasters? So I suppose I'm sort of inserting human fallibility in there as well. I'd love to hear thoughts from all of you on that.
Alan, do you want to pick that up first?
Yeah, well, I think as far as intended, I would agree. Initially, I think there were thoughts that it was going to be a benefit to the sub-postmasters, which is why we engaged with the process right at the start. How it's turned out is it doesn't seem to be for the benefit of it. It does seem to be for the benefit of the department more than anything else, to run it through at their speed and on their say-so. Can I just divert that question or the answer to that slightly and answer something I just thought about afterwards from that I was asked earlier? It was about if we went to court with this matter, and I was saying it might take 6, 12, or another 24 months in there. But what I should have also added at that point was that if deadlines are not set for the schemes to be finished, then there's every chance, certainly, as I was saying, there were more complex cases now that are going to go through. If they run the full gauntlet of what's available or part and parcel of these schemes, which is, to go back and challenge them a few times in there, then to take it to a panel and all the rest of it in there. If 100 or 150 cases decided to do that, that could take years in its own right to get that far. So it might be quicker for us to go back to court and get an end of a 12-month sort of finish line that we know we can achieve. This is one of the reasons why we feel a deadline must be set for these schemes. Sorry, I took it slightly different.
What was your perspective on that question?
So on the question I was asking, whether you had faith that the schemes are designed or intended to be designed with best interests.
I think the intent was there, yes, on paper, but I think when it's come down to actually dealing with it, there's just too much red tape, there's just too much, they're just wanting proof of everything, and so no, I don't think it's got the best interests at heart for that reason.
I have my doubts. I think that 3 things that still concern me. One is nobody has an idea where the 600,000 came from as a figure. Was it just a figure plucked from the air? In the recent budget, the Chancellor announced 1.8 billion for the whole package. The previous figure that we understood was 1.2. We don't know if that 1.8 is extra to the 1.2 or total, or is it does it include all the claims? Does it include the legal costs? We don't know. And then the other one, finally, is this business on timetable. I noticed yesterday the head of the 4 redress schemes at the post office told the public inquiry that, 302 million out of 1.22 or 1.8 has already been paid out. But by March 26, he expects it to be up to 1.5 billion. Now, a realistic timetable, thinking of the age of postmasters and what we've been through, I believe a realistic timetable would be March 25, not 26, for the whole settlement of, I think, that is the final message I'd give over. And if you think that these are for fairness for the postmasters, I think that's what I'd take from today and emphasise is, where did the 600k come from? Where did the 1.8k come from? And where is the timetable to aim a finish line for everybody that's going through all this additional pain now?
Yeah, very useful, thank you. Lastly, Antonia Vance.
Thank you.
So this is redress for what everybody accepts has been a massive miscarriage of justice. And it seems completely inappropriate for the processes to be so slow, so very legalistic, for the proof needed to be so high. I wonder if there were a way of doing this that could have a lighter touch in terms of the burden of proof needed and the weight that places on people to prove down to the minute detail their claim. And I wonder if you wanted to comment on that.
I think for me, as far as that goes, so the post office know who were postmasters, who were postmistresses, and for how long. They know when the Horizon system was fitted. They know when the postmaster left. Within that time, they know, because of what's come out about the system, that the postmasters and mistresses have been cheated, and they need to deal with it.
Anyone else want to pick up that question? Do you want to just put it again, Antonio?
Well, I did hear the question, and I was thinking about it just then. And I think a lot of the comments that I might make, I think you're going to hear probably from the lawyers, the solicitors, yes. When you, and I think that it's probably more important to hear it coming from them. You'll believe it more from them than from me.
Well, look, that concludes this panel. I want to thank you for the courage that you've shown, all of you, in coming forward and speaking today. This is not an easy thing to come and give evidence to a committee like this, and I want to thank you for your tenacity in pursuing this. What you've told us today is that after all of these years, even though you may have had minutes or hours to make good shortfalls, after years and years, you've still not had the redress to which you're entitled. You've told us that there's not enough help up front in actually putting the claims in. You've told us that fairness is getting lost when offers are put on the table. You've told us that it's a mystery, frankly, as to how some of these numbers are conjured up. And you've told us that there's a really clear need for deadlines around this process. And there's a real risk that if we don't have those deadlines, then sub-postmasters who have already suffered so much may be forced to go back to court. Thank you very much indeed for your evidence today. That has been invaluable. That concludes this panel. Order, order. Order, order. Welcome to the second panel for today's inquiry into fast and fair redress for the sub-postmasters. I'm very grateful to our group of lawyers who have worked incredibly hard for many wronged sub-postmasters in coming and giving evidence today. And because you're lawyers, we're going to have to read the sub judice resolution to give you the protections that you need. So at the start of, so there are relevant active legal proceedings relating to Horizon before the courts. In December 2022, Mr. Speaker exercised his discretion in respect of matters sub judice to allow references to those proceedings as they concern issues of national importance. That waiver is ongoing and it applies not only to speeches made by members on the floor of the House, but to remarks by both members and witnesses at today's oral evidence session. Nevertheless, members are urged to exercise caution in what they say and to avoid referring in detail to cases that remain before the courts. Members are also urged to bear in mind that Sir Win Williams Post Office Horizon IT inquiry is ongoing. Neil Hudgell, perhaps I could start with you. We've just heard a series of problems that bedevil all of the compensation schemes. I don't think we can say any one of these redress schemes is in good shape. Could you just give us a sense of how the experience you've heard compares to the experience of your clients?
Well, the two clients of mine that spoke today, Dowie and Jill, are pretty representative of the 400 or 500 personal stories that I've heard before. You know, each case is very tragic on its own circumstances. I think these are very humble, generous people. You know, you heard Dowie talk about how he felt fortunate, and I mean that really resonates with everyone, I think. And therefore it's all the more crippling when they come to a compensation process that actually heaps more injury on them. I think that we've discussed this before. That
you think the redress schemes as they're designed today are heaping injury on injury?
Well, I don't think it's just me that says that. You know, we've obtained significant volumes of medical evidence, which the Post Office and government have seen, that actually talks about the process of compensation as actually making people unwell. And you know, it's a real big thing for us around this whole issue of trying to simplify the process, trying to kick it on further gears.
We've got the biggest miscarriage of justice in British history. You've got a group, we think there may be at least 3,000 people who still haven't had their claims for redress met. And at the moment, the redress schemes are making them iller rather than providing them with the redress to which they're entitled.
Yeah, and as I say, I think that's validated by formal medical evidence. I mean, I think the other thing as well to say, and there's so much to talk about here, but in terms of things like the burden of proof being put to election on heads of loss, they actually think again that they're being cross-examined and disbelieved on matters. You know, you've advanced this claim that's 20 years old. You've no documents, but you've got no documents because we seized them and never gave you them back. You know, so they're actually placed in a very invidious position, and therefore, you know, it's incumbent on we can't revisit history, but what we can do is go from today and try and simplify things so that these really good people can try and rest a little bit easier.
James Hartley, is that your experience? Is this the experience of your clients too?
Yeah, I'm sorry to say it is. So we have acted for 419 of the postmasters of the original 555 that we acted for in the High Court proceedings. And unfortunately, yes, there are elements of similarity between what they are going through now and the legal process they originally went through to defeat Post Office. I mean, we have obtained 242 medical reports, almost all of which have identified medical conditions that our clients have suffered as a consequence of what Post Office did. So these are real human issues. I'll give a couple of examples in due course as to the sorts of situations that can add to the stress.
Right. What about your clients?
Well, sir, I mean, before this meeting you sat down with a group of postmistresses who've flown all the way from Northern Ireland to attend this committee. And during that meeting, they wept as they spoke to you, describing not just the financial losses, but the loss of dignity and their good name, which burns within them to this day. And they sit behind me. During that meeting also, I read you an email sent to me at 2 a.m. last night by Mr. Mark Kelly, who has travelled from Swansea today, where he spoke of his head spinning, having received one of these reasons for further information letters very late in the day, stopping the clock on his GLO offer That's supposed to be done in 40 days, stopping the clock at the late stage, asking him all sorts of ridiculous questions that he's incapable of answering and which the post office have the answers for. So, Mr. Byrne, you, and indeed many members of the committee, you understand only too well the utter devastation that has been caused in every single community in this country, because of course all of us know a victim of this scandal, because all of us have a postmaster or a postmistress a few hundred yards up the road from our homes.
Thank you for helping set the stage. We're going to go into each of the schemes now in a little bit of detail, because we need your help in developing recommendations for ministers about where the problems still lie. So if I could have the first slide on the GLO scheme, and I'm going to ask Matt Weston to lead the questioning.
So, is it going to come up? Or
may start, and the slide will hopefully
start. Okay, it'll catch me up. Really, just James, Mr. Harley. I understand you were before the committee before, and at that time you spoke about areas where you felt that the offers weren't fair, and I just wondered what improvements have you seen since then?
Well, the 213 of our 419 claims have settled, so that is good news. Within those are the £75,000 claims which were more straightforward. The vast majority of those 213 clients are happy with the outcome. They feel in all circumstances it was fair. However, we still have another 206 to resolve, most of which are highly complex claims involving medical evidence and accountancy evidence, and those, as I think Sir Alan mentioned earlier on, are the more difficult ones which will take time. So the GLO scheme, which is the only scheme we're involved in at present, can deliver fair outcomes. However, the other side of the coin is that unfortunately we are seeing not only delay, which we'll come to, but we are seeing offers which are not fair. And again, Sir Alan mentioned his concern that fairness appears to have become the secondary factor behind forensic legal analysis and detailed requests for further information. And that is our experience in quite a few cases, with detailed requests for further information, which also manifests itself in the levels of offers on particular heads of loss, which we feel are too low. There's more to be said about that, but so there's potential for fairness, and there are signs of fairness, but we still have concerns.
Just on that, to what extent do the first offers, how do they compare to what the claimants perhaps were expecting? Perhaps Mr. Enright can come in as well. The figures we have in relation to the claims we are handling in the GLO scheme, 27% of the first offers made, were for less than half of the sum claimed. Wow. Mr. Enright?
Yes, and we may touch upon this again, which is the benefit of the doubt issue. A client of ours, I think almost a month to the day, received his first offer under the GLO scheme from DBT, and a whole range of heads of loss suffered by him were reduced by 30% on the basis that there was evidential uncertainty as a result of gaps within the supporting evidence. There are 2 points about that. First of all, Mr. Worsfold is his name, we assisted him in getting a forensic accountant who put forward his losses, and that forensic accountant within that report discounted the amounts claimed on the basis that the forensic accountant themselves could not satisfy themselves in entirety to be able to support the claim. Then DBT themselves double discounted what is being offered by coming back saying that there are gaps in the evidence as a result of absences of evidence. Now, of course, there are absences of evidence because, as Mr. Hodgell has said and Mr. Hartley has said, this is 15 years on since he was forced into penury and when he had to take on credit cards and remortgage his home, etc. How could any one of us here find the evidence 15 years on to demonstrate those types of things? So he's being double punished and being given double the lack of benefit of the doubt. That needs to be brought back into this.
Okay. When you were before the committee before, I think you said that the post, in terms of post office disclosure, that there was a degree of inefficiency in incompetency. Has that improved since you were last before the committee?
That is less of an issue now because we've moved on from that. We eventually received the disclosure that we needed from Post Office, but that was only as recently as June 2024, so there were significant delays along the way. But now, current state of the position is that that isn't holding things up.
Mr. Enright?
In terms of hold-ups and looking at the process spreadsheet, if we look down to in the central block at the top, the first blue point, claimant applies in full, a named case facilitator from Denton's is appointed to manage the case. Now, what really happens is we formulate the claim and submit it to Denton's, who are effectively a highly paid post box. They post it on to DBT's lawyers, Addleshaw Goddard. Why do we need that layer? And what has happened, for example, in just the last 2 weeks, Mr. Keith McEldoy and Mr. Harry, clients of ours, what's happened? They've put their claim in and Denton's haven't sent it on. And so they're supposed to get an offer within 40 days. And we chase up Denton's and say, oh, we missed that, we lost that.
It slows the process down.
So a highly paid post box that doesn't really work.
Which slows it down?
Yes.
Interesting. A question again for both of you. Mr. Hartley, I think you suggested that that DBT should give sub-postmasters the benefit of the doubt at the evidence gathering stage. Does this actually happen?
In many cases, no. And if I can give one example, a recent example, yesterday we received a 3-page letter from Addleshaw Goddard DBT solicitors in response to a claim, and we had produced a psychiatric report, a medical report, which we had obtained for the client. The letter said that they felt the psychiatric report, so this is an expert consultant, was vague and lacking in detail. And this is a report in which the medical consultant had expressed the opinion that there was, on the balance of probabilities, the postmaster had suffered a condition of anxiety and depressive disorder. So medical consultant gives a view on a balance of probabilities, which is in fact is the legal test in this scheme. We then get a letter making that comment and also then following the letter up with 2 pages of questions about this person's prognosis.
2 pages of questions?
And their prior symptoms, i.e. addressing the question of whether in fact this was caused by Post Office's actions. Now that is not giving the postmaster the benefit of the doubt. And I think this also links directly into this point around how fairness should be assessed, and indeed the provisions are within the guidelines and principles of the scheme if they are used properly. So the guidelines for the panel, the independent panel, expressly say that the panel and the panel's approach should be the same as DBT's. The panel should approach cases with a holistic approach. In other words, looking at the case as a whole, looking at the postmaster's situation as a whole. and then arriving at a fair result based on legal principles. Now, DBT will, of course, say, well, to arrive at a fair result, one has to follow established legal principles of evidence and causation, etc. To which we say, yes, but in the relatively large bracket of legal opinion on a particular head of loss, UDBT should be offering at the very top of that bracket on cases by giving the benefit of the doubt and not taking an overly forensic legal approach. And to get to that result, DBT, we say, need to instruct their lawyers to take that holistic approach.
Just on that medical submission, the 2-pager, have we seen that, Chair? Or?
No, we haven't seen that.
Okay, be useful to see, I guess, wouldn't it? Just in terms of the dealings, Mr. Enright and Mr. Hartley, your dealings with Addleshaw, Goddard, and Denton's, have you had any positive experience in those dealings? And if not, why not?
I'll deal with Addleshaw's first. Yes, they have, for example, on particular cases, pick the phone up to us to have a discussion about a particular case rather than setting out details in what can be very stressful letters that the client then sees, questioning, well, the sort of example I gave to you. So yes, there absolutely have been positive instances. So it is not all negative. And of course, as a firm of solicitors, Addleshaws must follow instructions of their client, DBT. So all roads lead back to DBT, in fact. If DBT instructs Addleshaws or in any other law firm to set the bar in a different way on evidential requirements, that is what that firm needs to do. As for Denton's, we may talk more about this, but we don't feel that Denton's have been deployed by DBT in the way that we envisaged at the beginning of this scheme, which is to take a very proactive approach to finding the middle ground between the parties, finding a mutually acceptable resolution, which is precisely what the scheme guidelines and principles say Denton's were instructed to do. We don't feel that's happened, and we don't know why it hasn't happened, but we can only assume that DBT haven't given instructions to Denton's to operate in that way. I feel there is a big opportunity still for Denton's to take a significant role in resolving cases quickly and fairly.
If I may add, I think Mr. Hartley touched on the core of the problem. A lawyer, solicitor, is professionally bound to act in the best interest of his client, and for example, therefore, if you're representing someone, has to pay out compensation to try and pay out as little as possible. And what you need in the circumstances like this is a strong client. The DBT needs to be a strong client and direct its solicitors to act fairly towards a fair outcome. DBT needs to be the driver to say, you might be able to argue the pennies here. We don't want you to. We want you to take a fair view on it, a generous view on it, and drive towards a settlement. That's what's needed, a strong client. DBT needs to be a strong client.
You're surprised they're not a strong client?
They are. I think the Guardian reported on the 24th of August that the Post Office, etc., had spent £250 million on lawyers. Certainly we didn't see much of that, but they're hemmed in by walls. We have two sets of city lawyers, Denton's and Addleshaw Goddard's, representing the GLO. Why do you need two sets of city lawyers? How about one?
If I may add that DBT, I suspect, will say to the committee later this month that they, as guardians of taxpayers' money, they cannot simply take a view and look at the claims through the lens of fairness from the postmaster, because they've got to somehow apply some rigour to deployment of money. And I think everybody understands that as being a factor that needs to be borne in mind. But that, in our view, does not prevent DBT from making offers at the top end of a sensible, justifiable range in the way I described. That is entirely consistent with responsible spending of public money, in our view.
A final point on this, and this is according to the financial redress data. I think DBT is still outstanding something like a couple of hundred claims. When do you expect those to be submitted?
Are you referring to claims still to be submitted to that?
Yes.
Yes, and speaking from our perspective, we have 69 claims still to submit because there's been a lot of work going on medical reports, financial reports. So 69 still to go in from us for EATS. We've committed to DBT, and we can confirm this to the committee now, that we will have submitted the vast majority of all the claims by Christmas.
Vast majority being 90%?
95%.
So we've got 209 outstanding claims. You think that's going to come down close to zero on the GLO?
I can only speak for the 69 that we've got outstanding. Of those 69, I would say over 60 of those will be submitted by Christmas. There may be the odd one, individual postmasters who've got particular vulnerabilities, particular challenges, or there may be other reasons where a handful may take a little bit longer.
Right, we're going to speed up a bit, folks. So Charlie Maynard, over to you.
Afternoon. So Alan has called for all claims on the GLO scheme to be complete and paid out by March 2025. Do you think this deadline would be helpful? If not, why not? And just to add to that, do you have any recommendations if that date was picked about what steps need to be taken to hit it?
I start on the GLO scheme, and I have discussed this with Sir Alan. My own view is all offers to be made by end of March 2025 by DBT is realistic. Offers, that's a different perspective from resolving all claims by end of March.
I agree. For the same reasons, there are some individuals who are extremely vulnerable. In those cases, may take a little longer.
Okay, thank you. Are there other targets that could be set to help accelerate the speed of redress?
Yes, the 40-day time limit for an offer under the GLO scheme. What we've been seeing happening recently is that a claim is submitted, and 34 to 36 days into the time limit period, the DBT or Adult Show got it raised what are called RFIs, requests for further information, and restart the clock. Those RFIs should be identified in day 1, 2, or 3.
Thank you. And if I may, Chair, coming into this cold, or relatively cold, everything seems to start at the kind of the claimant's end, and a lot of onus on the claimant to put bundles of information together. How much visibility, I just want to double check this because I think you touched on it and I want to confirm, how much visibility do you now have in terms of full transparency of all the information the post office has?
Well, GLO, again starting with the GLO scheme, post office not involved in that scheme at all. So it's DBT.
I understand that DBT is administering the scheme, but essentially the post office, they were postmasters with the post office. So in terms of just seeing inside their systems about what they have on their register for Horizon per postmaster, do you have full visibility of all that information?
We don't need to in the GLO scheme. We have all the information we need. It may be different in...
I would just add that, and we discussed this with the Chair, that 18 months was missed at the start. The ex gratia scheme was announced in 30th of June 2022. It didn't actually become fully functioning really until Christmas 2023. So if we hadn't lost the 18 months, all the claims would have been over by now.
Okay, thank you very much. So I just want to make sure that I've completely understood this. So from our process map, you think that there is some delay creeping in from Denton's, and there is just a kind of an excess of rigour that is creeping in at the Adelshaw Goddard process, and that is slowing things down.
If you look between the last two blue bars and the centre point, there's the RFI point. That's where they come back with requests for further information.
And you've got a problem there, which is that the clock is getting restarted.
It gets restarted.
Once that's triggered, so we've got to get through that as well.
And excess rigour on looking at each head of loss, but also the first offers we think are the bottom, they appear in many cases to be the bottom end of what we think is an acceptable range.
But just on that, how clear are we about the discrepancy in the range of offers? We've all been struggling to get this information. I think some of you are beginning to build this information. But is there an inconsistency in the unfairness?
I don't think it is, because every claim is different, of course, factually different. Every claim includes different heads of loss. They're all complex. There is no formula that can be applied, I don't think, that can give any clarity on that, because it is all about legal advice and legal judgment on what is an appropriate level for damages for any given head of claim. So, for example, if a postmaster says, well, I had intended to invest in a buy-to-let property, but I wasn't able to, therefore I've lost the profit that I would have earned over X years.
It'll be unique.
Can be quite a complex subjective issue as to what that should be valued at. And there are numerous examples of that kind of thing.
It was very quickly.
I just wanted to ask a question about the reasons for further information. Could you say how many times they have been applied? Do you have, for example, are they using it once, or are they then coming back again? Have you?
I'll have to consult for a moment.
Just while Mr. Enright, I mean, from our perspective in the GLO scheme, it tends to be only once, but it tends to be quite a comprehensive one.
Right.
Normally once, but in some cases more than once.
Okay.
Thank you. Thanks for clarifying. Thank you.
Thank you, Chair. My questions are to Mr. Enright and Mr. Jill. Do you have any concerns with how the HSS is progressing, and could you outline what they are?
HSS?
Yeah, HSS.
Right. Where to start, I think. There are a number of fundamental concerns. I think the first concern is in the raw numbers. So at the minute, there are about 1,400 outstanding claims that have passed the eligibility test that are waiting for an offer. Now, offers are made by the panel, the independent panel, and presently they're sitting twice a week, so 8 to 10 times a month. Through each sitting they get between 5 and 10 cases determined. So on those numbers alone, it will take, and this is before we layer on top of that cases that come back for reassessment, it will take the best part of 18 months just to process those numbers. Now, that's the first point to make. Government hopes to wipe a lot of that away with the £75,000 fixed sum offer. My concern there is that they're going to wipe away a lot of legitimate claims that are worth considerably more. You heard Jill. Jill said before she came to us that she thought it was a fair offer. People don't know what fair offers are until they get proper advice. And so Simon McAldin, the director in charge at Post Office, was giving evidence at the inquiry today and yesterday. And we referenced one of our cases that started with an offer of £4,000. Now, Post Office's position on all that is that we settle the majority of the claims off. They're small claims, we don't need to be worried about them. But that makes dangerous assumptions, because the original scheme was framed as the historical shortfall scheme. So people claim shortfalls, but they didn't think about claiming consequential losses, because what follows from a shortfall is suspension, dismissal, loss of employment, loss of your home. So to come back to the example that we came up with yesterday, initial offer of £4,000, revised offer of £133,000, and that offer is still nowhere near good enough. So the problem of the £75,000 package is that it may sweep away a lot of cases, because those cases will not be eligible for the appeal mechanisms that's coming down the line as well. So you sign away an appeal right. The other problem with that is that you're not entitled to legal costs for advice on the £75,000 offer. So there's a real mix of issues around that. And then beyond that, and your sort of very helpful diagram sort of demonstrates the process, but there is wholesale deviation from the process. And that's been done at the post office end of it. So rather than offer from panel into dispute resolution, they've decided that the majority of claims that are resubmitted go back through panel reflow. And the net effect of that is that we're waiting for revised offers for periods in excess of 6 months.
Worse than that, though, isn't it, Dr. Hudgell? Because people are having their offers stepped down if they go back to panel.
No, they're not. No, there is a sort of jeopardy issue that I'll touch on if that's okay. But in terms of routinely every case that we've put back through panel that's come back for reassessment has had upside, very often significant. And again, this is referenced in evidence we submitted to inquiry this week. So one case went from 46,000 to 140,000, still not enough. One case from 363,000 to 649,000. That is enough. One from 21,000 to 172,000.
These are huge revisions.
Still not enough. Now, where the whole issue of jeopardy comes in is if you don't take, and this also goes to the same point in the new HCMS scheme,
it does.
Is if you don't take the fixed compensation, you could end up with less. So if you don't take 75, you could, and you fully articulate your claim, you could end up with less. If you don't take the 600 and you fully articulate your claim, you could end up with less. It's an example of duress being placed on very vulnerable and damaged people that is a worry, a serious worry.
I do hope that the committee are able to benefit from the excellent analysis prepared by Mr. Hudgell on the HSS scheme. It's a really fine piece of work. And I won't repeat it, one thing I would focus on is a built-in 9-month delay. So in many cases, there is no legal funding for advice, no funding for legal advice at the start. So you must do it yourself. So lay individuals, lay postmasters apply to the scheme. They have to complete a 28 question questionnaire, very detailed. About 6 to 9 months later, the HSS scheme come back with a request for further information again, which will contain somewhere between 50 and 150 further questions, many of which could only be answered by an expert accountant.
Say that again.
Or a doctor.
I'm right.
Yeah, the whole bit or the last bit?
Just the last bit. Just underline for the committee how many additional questions.
Thank you, sir. 6 to 9 months later, the HSS scheme will return to the lay unrepresented person and ask them some 50 to 150 complex questions, some of them multi-layered, that could only be answered by a doctor or a forensic accountant. And it is at around that stage, and we believe that this scheme is designed to wear people down. The person will do their best, put it in, and as Mr. Hudgell says, lay people will miss out head after head after head. And the HSS scheme will come back and say, take 75,000. How about that? And of course, at that stage, you've already had years. You've already had another year wearing through this. You're afraid of lawyers. You think you're going to, any money I'll get will be swallowed up by lawyers. And of course, it won't be in this scheme. But you can only get legal representation at the time when you're challenging the initial decision rather than getting the initial decision right on the first occasion. So spend a little bit of money at the start on expert legal representation. There's a very small pool of lawyers, and in fact you're looking at the three of them here, represent pretty much all claimants, working together extremely well, being involved in the design of all of the schemes as best we can. Spend that little bit of money at the start to help people make the applications. Let's try and get away from being compelled to go into the appeals process, or, as Mr. Hudgell has said, many people being undersettled, just going, look, I'll take the 75 and I'll walk away now because I can't take this anymore.
Am I right in thinking that actually having the 75 sum, even though, do you feel like that it's speeding up the redress? But I think what you're saying, it sounds like some vulnerable people, especially those you know, maybe from ethnic minorities that may not have English as their first language, those with any disabilities, or those just have got quite severe mental health problems, may find it difficult to access this and may go down sort of the quick fix.
We don't. We don't know the extent of the problem either, because a lot of these letters go directly to the applicants and are simply signed off by them. But I think the big point in it all is those poor people aren't best placed to take a view on whether, in some instances, £75,000 is generous, is a windfall, is more than they've lost. There are those cases because everything is very much case specific. But there's a huge danger, particularly when you look at the statistics around settlements without legal advice. It's nearly 90%. There was a YouGov poll that said that the statistics around that was where there's legal representation, offers are double. And so, I mean, that sort of speaks for itself a little bit.
Thank you. How long do you think it takes for a claim to be reassessed by a panel?
Again, it's case specific, but on average about 6 months.
And it says in the terms of reference that the aim is to convene on a weekly basis. Do you feel like this is happening?
Well, I think the panel are meeting weekly. I think the problem is the panel can only scratch the surface of the volume of work that's needed. I do have a solution, and it's a solution that I've shared, is that the scheme should stick to the rules. The rules do not provide for panel reflow. They provide for dispute resolution. Our experience of dispute resolution on the whole is positive. What you find is if you get a sub-postmaster in the room with the right people, and there are some people, it's important to give credit where it's due, there are some people within the post office organisation that want to help and want to reach a resolution to stuff. You get two people or two sides in the room, and you can achieve so much more. Unfortunately, the process as it's drafted and as it's implemented at the minute is too adversarial and doesn't give that opportunity for the sides to get together and actually reduce the areas of dispute. What you find that most sub-postmasters who want to put things behind them are happy with evaluation. It doesn't necessarily, they don't have to squeeze the pips and get every penny. If they get to a certain position where they feel that they can move on with their lives, then that's where they want to get to. So abide by the rules, forget the panel reflow, and resource up the ability to mediate or go through another form of escalation or roundtable meeting.
Move to that sort of external mediation, and are there any concerns of that stage?
External mediation, I can't give you a specific number. I can tell you that it will be incredibly low. I don't think 10, 12, 15 at a very low number.
And how many claims have moved to sort of the civil proceedings?
None have reached that stage.
Okay.
Thank you.
That's really helpful. So basically, the big bottleneck, we've got a couple of bottlenecks. So one is we've got a lack of advice at the front end, which is creating some problems. And then we've got this problem at the panel stage where the flow through is just nowhere near fast enough to get us to resolution. Thank you. Alison Griffiths.
You probably answered some of this, but if there's anything else, what else could be done to ensure the HSS is running smoothly and fairly?
I think it's resource. It's just getting enough sets of eyes in the right place, assessing the value of claims, making offers, and then getting into a simplified process that sort of reduces the legal confrontation. I think it's time and resource.
Because you mentioned mediation earlier, is there enough emphasis being put on the mediation stage, notwithstanding what you talked about going in at the front end?
Yeah, I'm talking about mediation in the broad sense. It doesn't necessarily have to be a formal mediator. As I said, there's some good people at Post Office. We have had instances where we've got in a room with 2-3 people from Post Office. They've heard the story of the sub-postmaster, because that's obviously incredibly powerful, and very often the information that's elicited actually gives them the opportunity to say, do you know what, this person does deserve the benefit of the doubt on X, Y and Z that they've not been able to document, that the panel has thrown out because of the lack of documentation. Having heard that person, because of course at the end of the day in any proceedings credibility is usually assessed in the witness box. There's no opportunity to do that in this process. And I think that is a real strong, powerful way to cut through, because it's all very dehumanised on the papers, and it's so powerful to hear these badly injured, damaged people and what they've gone through, and they are honest in what they advance.
I really appreciate that. And do you think the new independent appeals process will ensure that sub-postmasters at least get given fair offers?
I think the independent appeals process are we talking about the HCMS?
I'm looking to the chair for this one.
I think we're talking about the mediation process at the kind of the end of the process. So there is an outcome that can go to a dispute resolution procedure right at the end.
We never got to a formal mediated position at the end of the process.
Yeah, so we've just not got cases that have gone.
Well, there's discussion, sir, of an announcement of a new independent appeals process under the HSS, but it's just a discussion. There's no shape to it, and maybe if I could just add something that might help. Is in the original overturned conviction scheme for people who had a conviction quashed in court. Sir Gary Higginbottom, a former very senior High Court judge, sits over that in an independent capacity, has a firm hand upon the tiller of that, and therefore it is doing well because he's well able to case manage. We may get on to Sir Gary Higginbottom in relation to the HRSC scheme, the new quash conviction scheme. Which for some reason Sir Gary is not going to oversee at the moment. It seems that Denton's are. But why can't we have someone of standing of someone like Sir Gary Higginbottom, someone who well used to case managing large volumes of litigation, as he did for many years, overseeing the HSS, someone with of standing, someone we can respect, you can call before you, and who can speak to the whole scheme rather than the amorphous, uncontactable organisations that we have at the moment. Because this is one further point. There's no telephone number or email you can ring or you can use to contact the HSS to say, where is my case in the chain?
Yeah, very outrageous.
Thank you.
Thank you very much. We're going to move on to exactly that next scheme now, ACRS. Gregor Poynton.
Up there, Dr. Hodgell and Mr. Enright. As of September, I understand it's 1,030 Horizon-related convictions have been identified and quashed by the legislation. Yet our understanding is only 335 of those eligible claimants have been contacted as part of this. So I'm just keen to get your take on this and what can be done to inform those claimants of their right to that financial redress coming from this quash.
I may start. Primary problem. The Ministry of Justice, Department of Business and Post Office don't know how many beneficiaries of the Act there actually are. They have no idea. At the time the Act was being passed, they estimated that there were 900 individuals who would be affected by this, but they just don't know. They're currently saying in their 3rd of October quash conviction management information that's available online, it may be updated shortly, that they're now saying that there may be approximately 500 individuals who may be affected by this Act. If you don't know the size of the problem, you can't solve it, you can't monitor it. So the first thing is they need to pick up their musket, do the work needed to identify who this Act was supposed to benefit. Secondly, even using their unreliable figures that we have, we know that at a minimum, there's 124 people who have not been written to at all. It may be far higher than that from their own figures. It may be hundreds. Secondly, we know they've written to 335 individuals. How many have contacted them back? How many of those people are dead? How many of those people have moved? So let's get the number. How many letters did you send out? How many came back? Yeah. And then whatever the difference is, where are they? Yeah. And what is being done to identify the hundreds of individuals across this country who, as at this moment in time, have been vindicated, but have no idea that they've been vindicated, and have no idea that they are entitled to very timely and substantial compensation.
Yeah, I think To add to that, I have weekly meetings with the DBT, or my team do, and they're quite frustrated as well. I understand by the timing and the processing of the letters. There's a lot of missing information in many instances. I think it's fair to say the speed of the letters going out has been slow. My concern is that that's not going to improve, because the recent trend I've had is of letters that have asked for more information in relation to potential exonerees. So I don't know how many more on top of the 335 are going to get clean letters of exoneration. And the obvious concern is that this has all been in the public domain for 6 months plus. People have had convictions quashed in July, and they still, in many instances, don't know that they're free and exonerated.
Just finally on that, I mean, you talked about them picking up the musket and getting to work. Is that really? Are there any data sources then? There's
yes.
Available. It's just that they have not chosen to rigorously pursue that data and to find who these people are, where they are, and get communication out to them so they can begin to be part of this process.
We've had meetings on this issue, and we've been very clear to them. By way of example, Post Office have retained the services of a team of senior retired police officers to undertake investigations arising out of the inquiry. And we've said to them, why don't you use that team of senior police officers to track down these people? How about we use the police, the ones you actually have? Why isn't there a national and online campaign to identify these people? Because let's be clear, people in this room, the interested people here know it, they understand what's going on in Westminster. Ordinary people who are trying to pay their gas bill, etc., are not monitoring the proceedings in this room. They don't know. And so we need to find the ways necessary to reach out to these people, because it's a terrible burden to carry 4 years a wrongful conviction, as Mr. Byrne knows from the weeping people who met him earlier, to have their reputation in tatters and not be able to hold their head up high in public.
Yeah, and I think just picking up on some of that, I was just wondering if you could give us some idea. You may not have the perfect figures, and I'm sure you can send those through, but if you could give us an idea, both yourself, David Enright, and Dr. Neil Hudgell, on the proportion of the clients on the Horizon Convictions Redress scheme that you think will take up the 600,000 fixed sum.
Yeah, I can give you some statistics from the cohort of clients that we've got. It moves by the day, but in broad terms, we've had 160 exonerations, of which approximately 120, so 3/4, are taking the £600,000.
Mm-hmm.
Similar number.
Yeah,
similar number.
So, and with us as well, we have a number in that scheme, and we've that aligns with our experience.
Thank you. And then just taking that on one more point, do you think this is in line with the other overturned conviction schemes? And if it isn't, have you got any thoughts as to why not?
It's higher.
Mm-hmm.
Again, I'm sort of dredging the back of my memory now, but of the 80 odd exonerees we had in the first phase, the number was below 50%.
Mm-hmm.
So it's much higher. I think some of the reasons behind that is people just want done, and have actually probably seen the experience and read the experience of people that have gone before you heard Dowie. You know, I'm not getting into any of that nonsense for multiple years. I'll just take the 600 and I'll get on with my life. So I think there's quite a strong element of that involved.
Yeah.
Mm.
I would just add to that I think we share a concern that people under this scheme may be more liable to take the fixed fee because they are frankly afraid.
Thank you. That was going to be my next question, was whether fear played into it, because I think you touched on that earlier in some of what you were speaking to in terms of the pressure that people are under. So you do think that there is a proportion, do you think it's a higher proportion that are being impacted by that?
I think very, very probably, and that fear goes to this side of the fence as well. They're fearful of any professionals. You know, they've been so badly let down over so many years that they fear anybody in a suit, including claimant-owned representatives.
And then just lastly on that, have any of your clients progressed to the first stage offer yet under that? And if so, could you describe some of their experiences or your own sort of?
You mean to have the claim fully assessed?
So yeah, progress to that first stage under those schemes.
Lots of people have had the interim. A number of people have had final payments, but at the moment nobody has entered into the fully assessment, because we need to get the full history to understand, because remember again, there's jeopardy at play here once we enter into the fully assessed, because documents trump memory. So someone might think I earned X, Y or Z when actually you get the documents and the numbers are significantly different. So we've got to be really careful to make sure we do some sort of assessment for them. At the end of the day, it's client's decision, but ultimately we would advise them that it's premature to elect, because you're rolling the dice on something where we can't properly advise you on how the true numbers look.
Yeah.
Maybe end on a positive.
We've got a couple more questions, but you can. Let me come to John Cooper now.
Thank you, Chair. Mr. Dowie Lewis told us very movingly about his experience, and he said that although he submitted his claim in August, it took his appearance here, perhaps coincidentally, perhaps not, to actually trigger money arriving. How common is it for your other clients? I mean, obviously not all here, but how common is it for other clients to have quite lengthy delays before they see any redress?
Oh, it's more common than not for there to be delays. Everything can be truncated and shortened.
Just following on from that then, so have you any sense of why that might be? I presume you're in the dark, really. You've no idea why it takes so long. Is there any reason that you can see, or any common theme that you might have picked up?
I think one of the big things is putting enough people in the right places to blitz it, I guess. I mean, I think at the minute, as I say, government's eggs are in one basket in hoping that this £75,000, this £600,000 package cures all ills and takes away as many claims as possible.
Thank you, Chair. The Chancellor's announced in the budget that £1.8 billion for the Post Office financial redress. How do you think this money should be spent to ensure fast and fair redress?
The back office needs to be, I'm making the same point repeatedly. Now, the Post Office has spent £250 million of fees on legal costs. Now, that doesn't look like value for money to me. But I think it would be a false economy not to commit resource now to tooling up, to blitz through. I'm talking particularly about HSS, to blitz through what's there over the next 3 to 6 months. Because, Chair, if you remember, you asked myself and James last time how long are we going to be here? And we said up to a couple of years. And I'm now of the view at the moment within the HSS that that's optimistic.
Really?
Mm-hmm.
How many years would you now estimate?
Well, I'd have at least one. I'd say 3 years at the current run rate.
I think on GLO, in answer to the question as to spending the money, we've talked about increasing the level of offers. That's one way in which the money should be spent. We've talked about our views on significant increase in the deployment of Dentons, so that will cost money. But I believe there's a real opportunity there and a real need, incidentally, because I think if that doesn't happen, there's a very great risk of a large number of the GLO claims going to panel for a determination, which is not a a means of resolution. It's a determination which will bring an end to the claim, but it might not be a satisfactory end for the postmaster. So there's a real risk that a large number of claims may go to panel unless there's an intervention, or the Denton's type intervention we talked about.
Okay, and finally, do you have any? We're going to be meeting the minister soon to discuss this. Do you have any recommendations to them in the broad brush that haven't been covered already?
I think I spoke to the minister earlier actually about issues around the HSS. If I can put on your radar today, conscious that time is tight, that some of that budget needs to be allocated to scoping out potential redress for capture-related victims, which at the moment there is no redress. There's reports that suggest it is a problem of similar magnitude in some respects to Horizon. Lessons need to be learned, so there's a proactive management of a process, not a reactive one, a proactive one. So it's a conversation in itself, but I'm just putting it on the table for you to have in your mind when maybe you do meet the minister.
Thank you very much, Antonio. Anything else you want to wrap up with? No, perfect. Thank you very much indeed. I mean, that has been some fairly horrifying evidence. I mean, you've told us that we were spending about £250 million on post office legal fees, and yet the time that you estimate it's going to take to resolve this matter at the current pace has just gone up by about a year. But you've given us some very helpful evidence about where in the processes for these schemes there are things that can be done. But it sounds like, as you put it earlier, all roads lead back to the DBT, and a different kind of set of instructions are going to be...
May I just clarify, because I'm conscious that a lot of our clients
Yeah.
that listen to every single word, obviously, of this. I think you were talking principally about the HSS, weren't you, in terms of the timescale for resolution?
Yes.
On GLO,
yeah.
When I was last here, you had said between 1 and 2 years. I think the midpoint of that is 18 months, which would take us through to August 2025. And I think if a lot of the things happen that we talked about today, then I think full resolution of all the claims, or the vast majority of the claims, by August 2025 should be possible.
Well, that's the optimistic note on which to end, and you were keen for a note of optimism, Mr. Enright, on which to end. So let me just put this question then. With goodwill, some forensic reporting from this committee, and the acceptance of those recommendations by wise ministers, how much can we compress the timescale for just getting justice delivered?
What I made earlier about a strong client is crucial, and I noticed your colleague noting that. If the strong client, be it post office or DBT in the different schemes, directs its legal team to be generous, to settle at the top end of the band, we can drive through this very, very quickly. And secondly, if we have a firm hand on the tiller on each of the schemes, someone we can trust, someone you can call before you, these schemes can be delivered efficiently and cost effectively.
What weight would that?
That would look, in my view, that would look like someone like Gary Higginbottom, Sir Gary Higginbottom.
But in terms of a date, what do you think should be our target date?
I'm with Mr. Hartley in terms of the GLO. I do think that we can get almost all of the cases with offers by March 2025. There will be a few more. There are some clients who are so vulnerable, you simply cannot push them too hard. You have to work at their pace.
What's the kind of date we should be aiming for Horizon Shortfall Scheme?
We should be aiming for considerably sooner. I mean, the difference, of course, is that there's still claims coming in, and there's no cut-off date, so it's a bit more difficult. Anything that's currently on the books, I don't see why we can't have a resolution within 12 to 15 months, including the new ones that are still to be offered.
That's the note on which we shall end. Thank you very much indeed for sparing the time to come and give evidence to us today. The committee is hugely grateful to you. Thank you for the work that you're doing on behalf of the victims of the Horizon scandal. That concludes this panel. Order. Order. Welcome to the third and final panel for today's session of the Business and Trade Committee, looking into how we accelerate justice for the sub-postmasters affected by the Horizon shortfall scandal. I'm really grateful to you, Sir Gary, for joining us. You have got a particular role in a particular scheme, but you've also got the experience to be able to see across the schemes, and we're hoping to draw on that experience today as we draw up as a committee recommendations for trying to make this scheme as a whole go a lot faster. But perhaps I could just kick off by asking you, why was it important to establish this independent panel to accelerate redress for claimants who had their convictions overturned?
As you said, Chair, my role is in one scheme, and it's a fairly focused role in that scheme. And the scheme is very different from the other schemes. To begin with, it applies only to those claimants who've had convictions overturned by the courts, which, as you'll see from the draft report, which sets out the figures for the end of September, is 111. And because of the Act overturning the other schemes, and those claimants will go into a different scheme, that is now a closed cohort, I think. So we've got 111 claimants, and we will have no more. And the